Order, order. We can now move on to our next debate, which is about the effects of reductions in legal aid on women and families. I call Mr Virenda Sharma.
Thank you, Mr Chairman, and it's a great honour and privilege to present this report here in your chairmanship. Legal aid was first established by the post-war Labour government in Legal Aid and Advice Act 1949. It was established to ensure that ordinary members of the public who cannot afford legal fees can get legal service when they need them in areas such as family law, mental health, education, immigration and asylum, consumer, welfare benefits, employment and criminal defense. The aim of legal aid is to ensure individuals are able to defend or enforce their rights or to obtain advice on how to tackle the problems they face. As a result, it plays a key role in tackling social exclusion and helping individuals protect their rights against richer and more powerful opponents. And since its creation, it has formed a central plank of the post-war welfare state. It is the arm of the welfare state that keeps the other arms honest. It ensures they are all directed towards the public good. Legal aid funds private practitioners to provide this service rather than setting up a legal equivalent of the NHS. As a result, many legal aid practitioners provide support through a comprehensive network of outlets, often run by self-employed individuals in small partnership, as opposed to the state directly contracting lawyers. But that makes them uniquely vulnerable to major systematic shock, like the current plans to brutally cut social welfare legal aid. Yes, okay.
And also, can I congratulate him on securing this important debate, which I know he cares passionately about. But on the issue about funding and sustainability, does he not accept that our legal system costs over $2 billion a year and is one of the most expensive in the world, and in current economic financial circumstances is completely unsustainable?
Mr Sharma.
Thank you very much. I know my friend is a lawyer and practiced in the past. But at the same time, I will come back on that, responding to it. Let me start this one here. As a result, many legal aid practitioners provide support through a comprehensive network, as I said. And the government knows this. That is why the Cabinet Office has taken over this minister's mess and is trying to ensure the long-term viability of the advice sector. Legal aid support, particularly early intervention, demonstrates very effective values for money for the taxpayer. According to cost-benefit analysis by the CAV, for every £1 of legal expenditure on housing, debt advice, benefit advice, employment advice, I'm not going to give all the figures, which I'm sure are available to the members. As a result, it is clear that the savings made by cutting the legal aid budget will be dwarfed by increased cost elsewhere to the public purse. That is why cuts to advisory service, particularly to welfare advice, are both short-sighted and short-termist. But there is the human cost too. In any given year, legal problems such as divorce, eviction, or death will be experienced by 1 in every 4 people, 1 in 3 long-term sick or disabled people, 1 in 2 unemployed people, 1 in 2 lone parents. People with one unresolved problem often accumulate other problems rapidly. If you cannot resolve early-stage problems, more problems will often accumulate and end up in a vicious circle. These cycles can result in people losing their jobs and income, suffering stress-related illness, and experiencing relationship family breakdown. Yeah.
I'm very grateful to my honourable friend. I also congratulate him on securing this important debate. Would you not also agree that if we don't deal with the whole cluster of problems, in fact we allow problems to get worse? So, for example, if there are employment and debt problems and they're related, and we solve the debt problem but not the employment problem, we're merely postponing it. It will come back again.
Thank you very much for this important intervention, and I agree with every word my friend has said, and certainly I will come back again on this in my speech and developing this later on. Such problems are closely related to social exclusion, poor outcomes for children, and levels of crime and antisocial behavior, all of which represent significant costs to public service. Children whose families are experiencing civil and social problems are more likely to become involved in truancy, exclusion, and offending. For the last 40 years, local law centers have been providing legal advice and support to the most vulnerable and needy in their communities. I must say here that in the late 70s and early 80s, I worked as an advice worker in the law center, and I have experienced and dealt with the communities who suffered due to unemployment and other reasons. So law centers are an essential part of community life and are the first port of call for many people experiencing social and civil legal problems. Law centers must be protected because of their experience, working for 40 years with local communities, building a relationship with the public, landlords, organizations, local authorities, and projects like local access. They are well established in communities and easily accessible and most trusted by the communities. Trust, the brand power of law centers like Citizen Advice Bureau, has gained public trust and confidence. Face-to-face advisory services builds trust and stronger relationship with clients. Services provided by the 52 law centers in England and Wales can be divided into 3 strands: individual casework, education and prevention, developing policy. All 3 strands of services that law centers and CABs provide demonstrates the important strategic role played by these organizations in their local communities.
Assistance and advice centres, but does he also welcome the fact that this government will be spending £4.7 million to fund 44 court-based independent domestic violence advice positions across the country, which quite clearly shows this government is committed to supporting the most vulnerable in our society?
Thank you very much for this intervention, and I'm sure that I will be answering that later on in my speech. The issues raised in individual caseworks are often the root causes of the problems faced by communities. This places law centers in the unique position of being able to disseminate information to other support bodies and also to propose remedies. Research by the NEF has calculated the contribution of law centers by quantifying the social value such as institutions provide. They have found that for every £1 invested in the law center, a further £15 of social value is generated. Family legal works remains the most costly area of the civil, legal, and aid budgets. It covers the issues of child welfare and protection, as well as divorce, property, and relationship breakdown issues. The proposals have retained legal aid for cases where domestic violence or forced marriages is involved and for cases where children's safety is endangered.
I have some examples in my area of a lady who has reared her children, has left her job, depends upon her husband for income. There's a messy divorce takes place, and then she finds herself needing legal aid, can't receive it. Does the honourable member share my concerns as well in relation to those matters, that families and ladies in particular will find themselves very, very vulnerable at this time?
Thank you very much for this important intervention, and I quite agree with you, as I was stating earlier on, that this is the main cause of going to effect, and the impact of that will be on the families in the society. Abundant research has been carried out into the adverse consequences of family breakdown. There's also ample evidence that suggests job loss, financial difficulties, and loss of income can bring about family breakup. Therefore, the provision of advice for other civil law problems, such as employment, housing, and debt, are important in preventing problems from escalating. The government's proposal would seriously damage access to justice, especially for the most vulnerable in society. The Ministry of Justice Impact Assessment shows that there will be a disproportionate effect on women. Similarly, the cuts disproportionately impact on black and ethnic minority clients and those with disabilities. As legal aid is targeted to those with low income, it will have a disproportionate effect on this section of the community. However, it is likely that those on very low incomes will be particularly negatively affected. And then there is the domestic violence. I would direct the Minister to a speech of great power delivered by the noble Baroness Scotland in another place. In that, she put the following to the Minister Lord McNally. Look at the average case, such as when a woman has run from her home. She manages to go to her GP, who sees the injuries and notes them and then sends her to hospital because there are fears that she may have cracked a rib or an other bone. She is seen by the medical staff and they verify that the injuries that she complains are of genuine. Her neighbors may have come in to rescue her from an assault. They may not have seen the assault taking place, but have noted what was happening and taken her away. Social services may have come along and examined the children, spoken to them, and heard what they had to say. All of that might have been used by the police, who then came along and arrested the man. He may then acknowledge that he has indeed committed the offenses that are alleged against him. Even if all those things that had happened under the government's current provisions, the woman would not be entitled to legal aid. That cannot be right. Yeah.
Do not accept, in terms of the interdepartmental working between the Minister of Justice and Home Affairs, that the Home Office is providing over 28 million of stable funding until 2015 for specialist local domestic and sexual violence support services, and are providing 900,000 to support national domestic violence helplines and stalking helplines, which shows their commitment on this very issue.
Mr Sharma.
Thank you very much. Once again, you have brought a very good intervention, but at the same time, we need to look at the impact and where the resources are going, and I'm sure that is where the whole debate is. Yes.
I wonder my honourable friend would also agree with the noble Baroness Scotland that the definition which the government planned to adopt for declaring what domestic violence is could in fact result in some 46% of current cases which would would attract legal aid will no longer do so.
Thank you very much for, again, every member has been with a very good intervention, and I quite agree with what my friend has said, and I'm sure that it is noted and everybody recognizes that. She is a practitioner of great experience and ability, is of course right. Mr. Chairman, I'm fortunate enough to have the brilliant Southall Black Sisters in my constituency of Ealing Southall. They are one of the UK's leading organizations for black and minority ethnic women, and they told me that these women will be particularly hard hit by the government's plans. They said, the legal aid bill will make it difficult for all vulnerable sections of society, especially BME women, to access justice, and in doing so, remove meaningful legal protection from them and instead push them into community forums such as religious arbitration tribunals, where not only will they be denied justice and protection, but they will be encouraged to reconcile with the abusive partners in order to uphold so-called religious and family values. Women who have experienced and are at risk of violence and abuse will be at further risk of domestic and sexual violence, sexual exploitation, and forced labor. It has been widely reported as fact that women who have experienced domestic violence will still be eligible for legal aid in private family law proceedings, such as disputes concerning the care and upbringing of children. But this is simply not the case. Experts in the field have unanimously raised concern that too many women who have experienced domestic violence and are in need of help will fall through the gaps in the proposals. I think that I go first there.
Thank you, I'm grateful. Does the honourable member agree with me that men are actually likely to be more financially better off than women and therefore better able to pay for legal work privately, and also women are less likely to be in non-unionised jobs.
Thank you very much, and I quite agree every word you have said. I'm sure the other minister will also take note of that in his contribution later on. They cite two particular issues of concern. Firstly, the definition of domestic violence currently used in LAPCO is inconsistent with the cross-government definition of domestic violence, which guides statutory agency practice and governs access to government services. Importantly, the definition used in the bill fails to explicitly refer to the financial abuse and sexual violence, particularly insidious forms of domestic violence. It is not clear why a different definition of domestic violence is used in the bill, unless the purpose is to restrict the number of cases that will be deemed eligible for legal aid. Just a minute. Therefore, under the current proposal, many who are already known to be victims of domestic violence by other government departments will not obtain the legal support they need. Yeah.
I'm very obliged to my honourable friend for giving way. He's been very generous, Mr Chairman, in this debate. I wonder whether he might want to address briefly the fact that 23 special domestic violence courts are closing under this government's watch. How will that affect women?
Mr Sharma.
I think that I will come back. Thank you very much for the intervention, and I'm going to, when I'm summing up on the last line, you will hear that. Secondly, under the proposals, victims of domestic violence will be expected to provide objective evidence of that violence in order to qualify for legal aid. Experts unanimously agree that too many victims will remain ineligible for legal aid because the evidence that they will be required to present is dangerously restrictive. The evidence of domestic violence which the government proposes to accept relies on victims taking civil and criminal proceedings against perpetrators. Yet, we know that a large proportion of victims do not take these routes. To ensure that all women affected by the domestic violence are protected, it is essential that the evidential criteria used reflects the experiences of women and the reality of domestic violence. This must include evidence from specialist domestic violence organizations, health services, and social services. The government has failed to think through its proposals adequately. The notion we are all in it together is not alien to the Labour Party. Indeed, it may be the first time a Conservative Prime Minister has adopted a socialist slogan as his mantra. But these cuts are so deliberately, unashamedly, and I would argue viciously targeted at those that most need help. I'm looking at the time as well. I'm sorry, I'm indicated that I need to rush. And in the case of domestic violence sufferers, you can have no evidence. Minister, I ask you to think again, particularly on domestic violence. In its current form, the bill will leave thousands of women who have experienced the trauma of domestic violence, trafficking for the purposes of sexual and other forms of exploitation, and exploitation as a migrant domestic worker in a private household with the stark choice of representing themselves in legal proceedings or taking no legal action at all to protect themselves. But it will have a life-threatening impact on black and minority women too, who, as a result of cultural, religious, and other social pressures and racism, already struggle to access the legal system. The bill will violate the rights and fundamental freedoms of all vulnerable women, but will have an immensely disproportionate impact on black and minority women. It's not too late. And should you note, then I pray my colleagues in another place will make your mind up to you.
Thank you. Mr Jonathan Chernobyl.
Thank you, Mr Streeter. I'd like to congratulate the Honourable Member for Ealing Southall on securing this debate. It is an important topic and one on which we have discussed at length, and I recognise a number of Bill Committee colleagues on the floor today. It is still being discussed, as the Honourable Gentleman said in the other place, as the Legal Aid and Sentencing Bill goes through Parliament, but I welcome having a debate on this specific topic today. And it is notable that the title of this debate emphasises the effects of our reforms to legal aid rather than simply debating the justification for those reforms. It would perhaps be helpful, therefore, if I give the wider context to our proposals, without which a proper response about the effect on women and families cannot be given. And I start by confirming that the government is absolutely committed to the principle that domestic violence victims need support both legal and otherwise. The Home Office is funding over £28 million of stable funding until 2015 for specialist local domestic and sexual violence support services, and are providing £900,000 to support national domestic violence helplines and the stalking helpline. The MOJ has contributed towards the funding of independent advisors attached to specialist domestic violence courts since 2007-2008, and will have contributed just over £9.25 million up to the end of 2012-13. In addition, the Victim and Witness General Fund will provide a total of nearly £15.5 million in grant funding over the next 3 years to voluntary sector organisations that support the most seriously affected, vulnerable and persistently targeted victims of crime. Of this, nearly £4.7 million will be used to fund 44 court-based independent domestic violence advisor positions across England and Wales for the next 3 years. And, as my honourable friend was right to mention, we will also allocate nearly £3 million per year for the next 3 years to 65 rape crisis centres, and we are working with the voluntary sector to develop the first phase of the new rape support centres where there are gaps in provision. Domestic violence protection orders are being piloted in 3 police force areas. These are designed to give immediate protection to victims by banning a perpetrator from returning to the house, thus giving the victim the breathing space they need to consider their next steps. This, I believe, shows a real commitment by this government to tackling domestic violence, and if I may say so, a commitment that is rarely recognised or taken into account when directing criticisms to our proposals for legal aid. And I give way to the Honourable Gentleman.
Whether he would just address the point that I made in the earlier intervention. What effect does he think it will have on women when the government are closing 23 special domestic violence courts?
The Honourable Gentleman is avoiding the reality situation that in all except, and I believe it's less than 5 of those courts, the service is being transferred to other surrounding courts. But I will write him with the specific details because I don't have the numbers in front of me. With that context in mind, therefore, I will move on to the specific issue of the legal aid reforms. The £2 billion annual cost of legal aid, combined with the economic climate of the day, means hard choices need to be made. It is essential that resources are focused on cases where legal aid is most needed. That is where people's life or liberty is at stake, where they are at risk of serious physical harm or immediate loss of their home, or where their children may be taken into care. And as well as retaining legal aid for criminal cases, we're also keeping legal aid for mental health matters, asylum matters, debt and housing matters where someone's home is at risk, and legal aid for judicial reviews of public authorities. All of these are directly relevant to family welfare. Particularly relevant for the current debate, it also means retaining legal aid in order to seek an injunction to prevent domestic violence, to oppose a child being taken into care, and it means retaining legal aid for private family court law cases where domestic violence is a feature. We will also be keeping and extending legal aid for family mediation. The power to waive the financial eligibility limits in cases where someone is seeking an injunction against domestic violence will also remain. So those who need to get help and protection will be able to do so. I will.
Does the First Minister not agree that excluding undertakings from the domestic violence gateway could have the perverse effect of actually encouraging litigation and potentially increasing costs?
Well, as I said in committee, the government is looking at the question of undertakings, and that continues to be our position, and we hope to come forward as the bill progresses through the other place with that. I have to say, if I'm going to say very much more, I'm not going to be able to take any further interventions. We're also retaining legal aid for all child parties in family cases. And of course, exceptional funding will be available in any out-of-scope case where a failure to provide legal aid might breach the European Convention on Human Rights or EU law. Taken together, we expect these provisions to mean that we will continue to spend around £120 million a year on private family law legal aid based on 2009-10 figures. When you include legal aid for public family law matters, spending will well exceed £400 million, again based on 2009-10. We will continue to spend nearly £130 million a year for legal representation for child parties. This represents around 95% of current spend. I do accept that women and children will often be directly and indirectly affected by private family law proceedings, and as I've said in the past, we have had to make some tough choices here. We cannot afford to fund generally lengthy and often intractable disputes in the family courts. However, we know that mediation can lead to better results that are consensually agreed less acrimoniously and that are potentially longer lasting than those imposed by a court. And we do expect an extra 10,000 mediations a year, up from around 15,000 currently. Mediation, however, will not always be appropriate, particularly when domestic violence is involved. We know it can have a devastating effect on women and children, as well as men, of course, so I should mention are a significant and often overlooked group of domestic violence victims. Domestic violence is also a significant predictor of children being taken into care, as well as a precursor to all sorts of other social problems. On top of this, we also know that perpetrators of domestic violence can assert a controlling, insidious power over their victims. This could potentially stop a victim from effectively presenting their case against the perpetrator in court, for example. On these points, I agree with the Honourable Member for Ealing Southall and indeed Baroness Scotland, although the example used by the Honourable Member about a woman who wouldn't get legal aid after running from an abusive husband is not actually accurate. That sort of case would get legal aid. That is because where convicted of domestic violence against the partner will be eligible as a conviction would count as evidence. So this is why we have made a large and extremely important exception in our proposal to remove most private family legal aid from scope. That is where domestic violence is a feature. I know that there has been much debate about the definition of domestic abuse in the bill and the fact that we do not use the ACPO definition. And we are looking at that as the matter proceeds through the other place. There has also been much focus on the evidence criteria for domestic violence. This was raised by the Honourable Gentleman to qualify for legal aid in private family law cases. We do need the government submits clear, objective evidence of domestic violence to target taxpayers' money on cases where the victim needs assistance. The allegation, again made today, that the government's criteria will miss a great number of genuine victims, and various pieces of evidence that have been adduced to support this have been put forward, and we will continue to look at these, including the evidence provided by Southall Black Sisters, who I do appreciate have made a significant contribution to the whole case. But the point I'd like to make here is that these pieces of evidence refer to domestic violence victims as a whole, pointing out their difficulties in dealing with the civil or criminal justice system, for example. We are dealing with a subset of that group, those who are seeking private family law legal aid. They will have, in certain respects, slightly different characteristics to domestic violence victims as a whole. By definition, they will be engaged in the civil justice system. A significant number, nearly 10,000 in 2010, will be seeking civil legal aid for a protective injunction at the same time that they seek legal aid for their private family law matter, and they will all meet the evidential criteria. We know that in total there were 70,000 legal aid family cases in 2009-10. Let me compare that figure to the prevalence of the types of evidence we are requesting. Around 24,100 domestic violence orders were made in 2010, the great majority with the benefit of civil legal aid. Around 74,000 domestic violence crimes were prosecuted in 2009-10, and there were 53,000 domestic violence convictions. Around 43,000 victims of domestic violence were referred to multi-agency risk assessment conferences in the 12 months up to June 2010. We also propose, as an ongoing criminal proceeding for domestic violence, and a finding of fact in the courts will be taken as evidence. Now, these figures will clearly overlap to some degree, but what this points out to is that a significant proportion of those 70,000 family law cases that we currently fund will continue to be funded. We think this proportion will be around 25%, which matches our rough estimate of the prevalence of domestic violence. Though I should also say that this comes from a number of sources and definitive evidence is not available. I've also committed to look again at whether the issue of undertakings in a court can be used as evidence. We are clear about the need to ensure that those who are victims of domestic violence and need legal aid can access it, and these requirements are designed to enable that. Turning to legal aid for children, we have protected funding in areas that specifically involve children. We have retained legal aid for child protection cases, civil cases concerning abuse of a child, and for cases concerning special educational needs assistance. We have also made special provision so that legal aid is available for children who are made parties to private family proceedings. I should highlight that in civil cases such as clinical negligence, claims brought in the name of a child are usually conducted by their parents, acting as the child's litigation friend rather than the child themselves. This is a normal part of the rules around civil litigation. As I mentioned earlier, there will also be exceptional funding schemes for cases where legal aid will not generally be available, which will take into account a person's ability to represent themselves in legal proceedings where the ECHR applies. This will clearly be an important factor in the case of children who might otherwise be left to present their case without assistance. It is worth noting that the government published an equality impact assessment. This laid out our assessment of the effects on women of planned changes to legal aid. It recognised the potential for the reforms to have an impact on women and children, but in the context of the cuts that need to be made and the deliberate focus of legal aid on those who are most vulnerable and in need, we do not believe that this impact is disproportionate. I do not pretend, Mr Streeter, that the choices we have to make will have no impact, but they do need to be made.
Order, order. Thank you. Good timing.